Committee on Health, Education, Labor, and Pensions will please come to order. Senator Murray and I will each have an opening statement, then we'll introduce our witness, and after our witness testimony, several senators will have 5 minutes of questions. Welcome, Mr. Secretary. Thank you for being here. Mr. Secretary, as you know, I urged the President to appoint an Education Secretary because I thought it was important to have a confirmed secretary accountable to the United States Senate when the department was implementing the new law fixing No Child Left Behind. And you've sworn to discharge your duties faithfully. That's your oath of office. And you've said in hearings here that you would, quote, abide by the letter of the law. So this hearing is about whether your employees are doing that or not doing that. I don't think I need to rehearse the fact that this bill passed by a huge margin, 359 to 64 in the House, 85 to 12 in the Senate. The President signed it, called it a Christmas miracle. The reason we were able to achieve such unusual unanimity and consensus is, to put it bluntly, is that local school boards, classroom teachers, and states had gotten tired of the United States Department of Education telling them so much about what to do. And that wasn't just Republicans complaining or governors complaining. You often hear that kind of thing when it comes to giving responsibility to those closest to the children. This came from the school superintendents, from the National Education Association, from the American Federation of Teachers, from the chief state school officers, almost everybody involved in education. There hasn't been a broader coalition in a long time. They objected to the fact the department had become a national school board, telling Kansas what its academic standards had to be, telling Tennessee how to fix failing schools, telling Washington State how to evaluate teachers. So the legislation we passed not only got rid of those things, we went further in a remarkable way and have explicit prohibitions on what a future secretary might do. This was all a dramatic change. It's called the biggest devolution of responsibility for education from the federal government to states in 25 years. But as it's not worth the paper it's printed on if it's not implemented properly. This is the second in what will be at least 6 hearings on oversight of the implementation of the new law. Already we're seeing disturbing evidence that the Department of Education is ignoring the law that the 22 members of this committee worked so hard to craft. It wasn't easy to pass the law. There were crocodiles lurking in every corner of the pond. One of those, and I see Senator Bennett here because we've had vigorous discussions over this, was called the issue of comparability. That's a provision that was put into the law first in 1970. It says that school districts have to provide at least comparable services with state and local funding to Title I schools and non-Title I schools. But the law also says that school districts, quote, shall not include teacher pay when they measure spending for purposes of comparability. This committee has debated several times whether or not teacher pay should be excluded. Senator Bennett, for example, he not only felt strongly about this, he had a proposal to change it. It wasn't adopted. I felt strongly about it. I offered an amendment to change it. It was defeated. So ultimately, we made 2 decisions about this issue as reflected in the law we passed last year. First, we chose not to change the comparability language in the law, so the law still says teacher pay may not be included in that computation. And second, we added a reporting requirement that school districts should report the amount they spend on each student, including teacher salaries, so that parents and teachers could know what's being spent and could make their own decisions about what is fair and what is equitable rather than the federal government mandating it. The one thing that the law that the President signed in December did not do was change the law that says teacher salaries may not be included when you're computing comparability. But here's what your department did on April 1. You tried to do what Congress did not do last year, and you tried to do it by regulating another separate provision in the law. In a proposed rulemaking session, here's what you proposed: forcing districts to include teacher salaries in how they measure their state and local spending, and to require that state and local spending in Title I schools be at least equal to the average spent in non-Title schools. If that were adopted, your proposal would require a complete, costly overhaul of almost all the state and local finance systems in the country, something we did not pass in the law. It would force teachers to transfer to new schools, something we did not pass in the law. It would require states and school districts to move back to the burdensome practice of detailing every individual cost when the purpose of the law as expressly written was to relieve some of that burden. According to the Council of Great City Schools, your proposed rule would cost $3.9 billion just for their 69 urban school districts to eliminate the differences in spending between the schools. Now, I'm not interested today in debating whether it's a good idea or a bad idea to include teacher salaries when computing comparability. The plain fact is the law specifically says the department on its own cannot do it. Mr. Secretary, not only is what you're doing against the law, the way you're trying to do it is against another provision in the law. To accomplish your goals on comparability, you're using the so-called supplement, not supplant provision that's supposed to keep local school districts from using federal Title I dollars as a replacement for state and local dollars in low-income schools. Now, according to a Politico story published on December 18, the former Secretary of Education said, quote, "Candidly, our lawyers are much smarter than many of the folks who were working on this bill," unquote. I don't know whether that means the 22 senators on the committee or all the staff sitting behind us. And I'm not sure how smart we are, but we're smart enough to write a law in plain English, and we're also smart enough to anticipate that your lawyers would attempt to ignore what we wrote and try to move around it. So we included specific prohibitions in the so-called supplement and supplant provision that would prohibit you from doing the very things you're proposing to do. Section 1118B4 says, quote, "Nothing in this section shall be construed to authorize or permit the Secretary to prescribe the specific methodology a local education agency uses to allocate state and local funds." And Section 1605 said, "Nothing in this title shall be construed to mandate equalized spending." Now, Mr. Secretary, I'll have more to say about this in my question time, and I'm going to ask you about this. But I want you to know, and particularly those lawyers who think none of us are very smart up here, I want them to know that I'm smart enough, and I believe there are others too, to use every power we have to make sure the law is implemented the way we wrote it, including our ability to overturn such rules when they become final, and including using the appropriations process. And if you try to force states to follow these regulations that ignore the law, I'll encourage them to request a hearing, which they have a right to do with the department. And if they lose, I'll encourage them to go to court. I'm not the only one who can read the law. You're going to come up against a coalition that's as broad as anything we've ever had in education, of governors, teachers' organizations, chief state school officers who are tired of your department telling them so much about what to do about the 50 million children in 100,000 public schools. They've already sent you a letter about that. Wisconsin Superintendent Tony Evers, a well-respected state chief school officer and a member of the rulemaking committee, said last week congressional intent isn't necessarily being followed here. The School Superintendents Association say that the prohibitions in the law in tandem with Congress' deliberately act of leaving comparability unchanged makes a seemingly tight case against expanding supplement and supplant. Now, you've testified here that you will abide by the letter of the law. It's not abiding by the letter of the law to require local school districts to use teacher salaries and equalize spending between Title I and non-Title I schools. It's not abiding by the letter of the law to use supplement, not supplant provisions to achieve your goals for comparability when Congress debated the issue and chose not to make any changes in the law. I'm making such a point of this today because we're at the beginning of the implementation of a law that affects, as I said, 3.4 million teachers and 50 million students in 100,000 public schools. The states are busy working on their plans for Title I money. They have a clear law that changes the direction of what federal policy is. I'm determined to see the votes implemented the way we wrote it. I think it's important at the beginning of this implementation to make sure that you, as well as those who work for you in the department, understand that. They are not elected to anything. And you are confirmed by the United States Senate to faithfully execute the laws, and you said you will abide by the letter of the law in your confirmation proceeding, and I expect that to be the case. Senator Murray.